All rise.
The Kosovo Specialist Chambers is now in session.
Please.
Be seated. Court officer, please call the case.
Good morning, Your Honors. This is case file KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
I note for the record that the four accused are attending via video today. As for today's session, we will take a break around 11 a.m. We will resume at 11:30 and continue until 1. If necessary, we will break for lunch. We will then resume at 2:30 and continue till 4 if necessary. We hope it will not be necessary to go beyond 1 p.m., and therefore we ask all parties and participants to ensure that all submissions are as short and focused as possible. As you all know, on February 15th of this year, the panel scheduled this status conference. A written agenda was circulated on 15th of March, 2023. As indicated in the agenda, the panel will seek answers from the SBO and the defense on time estimates for the first 12 witnesses and the corresponding impact upon the time required for SBO's case, and I'll turn to that matter now. I recall that during our first conference in December and during the SBO preparation conference in February, we have been asking the SBO to take a hard look at reducing the size of its case. And the panel notes that the SBO has taken some steps to reduce its case. Notably, the SBO has reduced the number of witnesses and hours required. The charges remain the same. The panel is also mindful that the defense estimates is a factor which adds to the estimated time required for this case. Nevertheless, the present timetable for this case, if unchallenged by the panel, is that the evidence of the first 12 witnesses is estimated to take 234 hours, which is the equivalent of more than 45 days of courtroom time. This means that the presentation of the SBO's case may take much longer than the SPO has anticipated. If we apply these time estimates to the case before us, the panel would finish the first 7 witnesses by the summer recess. The panel would thereafter have to continue with the first 12 witnesses, which would not be finished until September or October of 2023. If the same time estimates are used to calculate when the next batch of 12 witnesses would finish, they will finish on or about January of 2024. And then there are still 3 months, January, February, and March, to round out the year. And I've added some witnesses to accommodate that estimate. The panel considers that if it adopts a generous approach, we would manage to hear about 45 or 46 witnesses in a year. Based on the information currently before us and with 312 witnesses, which is the last reported number of witnesses by the SBO's case, including cross-examination, would take at least 6.5 years to complete. The panel considers that 6.5 years for the presentation of the SBO's case is excessive. We have indicated our position before that the SBO takes steps to reduce the size of its case, and the panel also considers that steps have to be taken by the defense to reduce its time estimates for the cross-examination of witnesses. I'm going to ask for submissions from the parties, from each of you, and from Victims' Counsel, who has been quite minimal in his estimate of time. I appreciate that. as to what steps can be taken to reduce the time estimates required for the first 12 witnesses. And I do actually expect to have some ideas here. This is not a time for vague answers or putting it off. We're getting close to the beginning of trial. Mr. Prosecutor.
Thank you, Your Honor. Just a preliminary point for the record before starting. We're in a smaller composition today than before, and our appearances would be Ward Ferdinandus, Sebastian van Hooydonk, and myself, Matt Holling.
Thank you.
If you'd like, I can speak to the first point in the agenda, although what Your Honor has just said covers the first 2 points in the agenda. For the first 12 witnesses, we do intend to revisit those estimates. We're going to revisit them in response to all information we receive and any developments in the proceedings. And that includes, Your Honor, specific directions for witnesses in the Rule 154 decision of last week. And this is F0-1380. As we are preparing witnesses for court, we're going to be continuously trying to focus down these hours and to reduce the time. We also have a very strong interest in being efficient and in being expeditious. No one wants a 6.5-year-long SPO case. And we know that we have to be efficient and expeditious in order to present the case we know we need to make. As to measures, and this is going into the second part of the agenda, Your Honor, I can address this now if you would like to. There are indeed a great many measures that the SPO can take to reduce the duration of the trial. Many have been discussed before. Many are in the rules. Rule 118.1, as mentioned in the trial preparation conference and the SPO preparation conference by this panel. All options are on the table for us. Even those in Rule 118, removing repetitive witnesses, narrowing charges in the indictment, reducing the number of crime sites or calling a representative sample, shortening the length of direct examinations, all are continuing to be considered. But what we would say is that the appropriateness of these measures does depend on the stage of the trial, which is why we are assessing this on an ongoing basis. At the moment, what we are focusing on, and as Your Honors have seen, is reducing our direct examination estimates and making targeted cuts to our list of viva voce witnesses. As just acknowledged, we have cut, I think, over 150 hours of direct examination estimates last month and 11 witnesses from our list. One important factor within our control that we wanted to emphasize, early witnesses are going to provide critical information as to whether further witnesses can be introduced in writing or dropped entirely. We have voluminous evidence on KLA communiques, just as an example. We've got the communiques themselves. We have statements in the media about them. We have documents from the accused house. We have statements from the accused about them. We have witnesses of inside and outside the KLA speaking about them. As we understand it, a little to our surprise, the authenticity of the KLA communique seems to be being challenged by the defense. So we're going to need to prove that. But we don't necessarily need to present all of our evidence in order to prove that. And as we present early evidence and witnesses testify, we're going to make adjustments once we consider the matter to be established. So with all this in mind, the global hours estimate that Your Honor is using with the extrapolations of the numbers, and this is in F0-1291, that still remains the best estimate that we can give. But unnecessary or duplicative witnesses are going to be addressed by us as the trial goes along. There are a few other matters that can also reduce trial duration that are outside of our personal control. Good faith efforts by the parties to reach agreements to reduce the scope of the issues in dispute is a prime example. Your Honor also mentioned defense cross-examination estimates. And on this one, we would appreciate actually some further clarity in today's hearing from the defense on these estimates. As Your Honors recall, each of the individual defense teams communicated their estimates at different times. And when combined with the size of the global estimates, it does call into question whether the defense was actually coordinating when developing these cross-examination estimates. Even with allowances for the fact that Rule 154 witnesses are going to have a relatively longer cross-examination than direct, these global examination estimates are extraordinarily long. And we find it hard to imagine that they would be warranted. Scheduling flexibility is another point, and I understand we're going to be speaking about this perhaps later today. The court schedule is clear, but there are going to be opportunities where sitting extended hours one day or maybe part of a Friday is going to be the difference between hearing an extra witness and not. And we'll at least say for our part, we're going to be proactive in identifying those opportunities to inform the trial panel's scheduling decisions. At the last hearing, Your Honors set a target date for us to close our case in April 2025. That's reasonable. And that's attainable. But it's going to require all parties, defense included, to be reasonable and efficient in how it conducts these proceedings. And we're going to say for our part right now, we're going to keep our case constantly under review. Thank you.
All right, Mr. Thaçi, defense. Mr. Keogh, you have the floor.
Good morning, Your Honor.
Good morning.
Your Honor, we have,
You only have to cut your estimate in half.
Is that all? I take, as a matter of fact, if you look at witness 3, someone for whom the SPO has given us hundreds and hundreds and hundreds of pages, they've decided to go live with him, and he's 10 hours. So I'm not quite sure what's going to come up new in those 10 hours, but certainly exploring cross-examination is going to be lengthy because I don't know what they're going to do. And that also applies to their number 7, where they now have 12 hours for a viva voce, not 154. And last but not least, on the first 12 list, we have number 10, who has 9 hours. By the way, both number 7 and number 10 likewise have hundreds of pages. I haven't counted them all, Judge. I try to perish the thought when I look through the binders of information for each of these. And we don't have any idea what they're going to say. Are they going to say something independent of what they've given in sworn statements to the SPO? Are we going to start this anew? Is there going to be new information coming from these people?
Have you asked that question?
Of these folks? I'm trying to get through this stuff first, but we are going to ask that question. And I will ask that question now.
Well, no, you don't have to ask it now, but the trial's going to start pretty soon, so
Well,
I would
Judge,
suggest you get to
it's
it.
part of the daunting task here, and I hate to sound glib here, is just getting through the 40,000 pages plus unredacted information that the SPO has. Did I do something wrong? Oh, I'm going to the wrong microphone. Apologies, Judge. I'll never be a singer in Las Vegas. Going through the information that has been handed across the transom. Now, I will say this, Judge, we have been consulting, and we've certainly started on the beginning witnesses. We have consulted with co-counsel on areas that we don't want to repeat. Who's going to cover a certain area? I was talking to my colleagues on the Salimi team this past week about issues that are uniquely involving Mr. Salimi that we, of course, are not going to cross-examine on, and likewise Mr. Strong with regard to Vasily. So are we coordinating and talking about what we're respectively going to cover? Yes. But this is their particular array of witnesses. And suffice it to say, even if we look at witness 6, where they have 3.5 hours, there are hundreds and hundreds of pages of exhibits, hundreds, that they want to get in through this witness, that they, I assume, are just going to put across the transom and say, did you have any involvement in the preparation of this treatise? And they say yes, and they want to introduce it into evidence without exploring the content of all of that document, that documents, I should say. So that is, the 3.5 hours there is misleading, given the amount of information that the SPO wants to put in. Now, these are their witnesses. They put these people forth. They're telling us what exhibits they want to put in front of them. There is no way in 3.5 hours are they going to explore all of that information.
My question was about ideas you might have for shortening the thing, not shortening their case, but shortening your case.
And the idea, Judge, is what defense counsel do here and have and should do, which is we talk among ourselves as we go through this, and we don't repeat things.
So, for example, on the first witness, there's 16, 18 hours worth of examination, 15 of which is yours, not just yours, I mean the defense.
Yes.
Are you saying that that's still accurate today, or is this a number that came up and you hadn't consulted yet?
That number we came up with on that, we had not consulted yet.
Okay, so is it safe to say that, at least as far as you're concerned, that this is a larger number than necessary on number one?
Yes.
Okay. Can you tell me on yours, do you still believe 7 hours is accurate?
Can I just consult with my...
And I'm not going to go through each one of these with you. I'm just asking
but
as an example.
Mr. Misitich is much smarter than I am, and he is going to cross-examine this witness. Mr. Misitich said, advised that we're going to try to be conservative and go less than that, but a lot of it depends. This is a very significant witness, and on how this witness responds.
Okay, that's all. I'm not trying to nail you down to one number, but it is important that we acknowledge that these figures were adopted before there'd been significant consultation between the defense.
And yes, number one, Judge, but also before we had the opportunity to wend our way through the thousands of pages that were disclosed,
okay.
which you know, I'm sure you know, Judge, you look through documents and you just dispense with them, they're of no consequence, but that's not the case with Metrodis, that we needed to and continue to spend a significant amount of time on a lot of the information.
How do you feel about the April 2025 target date?
Judge, I hope and pray that we finish before that.
No, I don't want your prayer. I want to know what you think, if you think this is entirely possible.
Yes, I think it's possible, Judge, because I think that as opposed to throwing everything into there, if you look at, for instance, the bar table motion, we have hundreds and thousands and thousands of pages on information that is tied to nothing that we're trying to wend our way through. Do we need to clutter up the record with all of that stuff? Do we need to go through all of that stuff as opposed to putting it through a witness? That is what's going to take the time.
Well, I think you've been a prosecutor before in your past, and I think you know that it's nice for the prosecution to have the ability to try their own case. And if they think it's important, we start out with the assumption that it probably is important. Now, we can lose track of that quickly, but that's the way we start.
And Judge, as a prosecutor for many decades in my prior iteration of my career, I will tell you, Judge, that less is better.
Yeah.
I mean, I don't think there's any
And on
question.
cross-examination as well.
No question. No, absolutely, Judge. Repetition on cross-examination does not benefit anyone.
I appreciate the candor, and I don't want to make this hearing longer than it ought to be, so let's let Mr. Visay, if you have something else to say,
Just one thing.
say it.
With regard to new evidence that if they intend to bring in with all of these people that are coming in that are viva voce, that are not tied to 154, we of course object to any new evidence coming in that hasn't been disclosed to us, but I think that the court understands that.
Understood. Thank you. All right, Mr. Visay, I will say that your numbers are a bit more reasonable, or let's not say reasonable, they're a little bit shorter anyway.
No, I'm grateful for that. We are, I think, at the moment, approximately 50% shorter than the next estimate, roughly. The total estimate of the CD cross-examination time for the first 12 witnesses at the moment is 25.5. You will, I'm sure the bench will understand that when giving estimates, one is focusing on what might subsequently be treated as an outer limit rather than a real estimate. So going back to look at the matter again with a view to giving real estimates rather than outer limits, we can shave off another 5.5 hours, and I'll give you the details. Witness 2, we can reduce from 2 hours to 1. Witness 3, we can reduce from 5 hours to 3.5. Witness 4, we can reduce from 2 hours to 1, and with a very clear caveat that it's an estimate rather than an outer limit, with witnesses 5, 9, and 11, we can reduce to 30 minutes, and with witness 12 to 1.5 hours. Those will all be on the record, I should say.
Thank you. Mr. Roberts?
Good morning, Your Honour. Obviously second what Mr. Kehoe has already said in relation to the estimates that we've given. We've only given 5 estimates so far. We're still working on providing the estimates for the other witnesses. We will do so in due course and as soon as possible, and we'll obviously make those as reasonable as possible. In terms of suggestions for streamlining the case, this will come from us, but it also will be one that requires input and control from the bench and obviously cooperation from the prosecution, and that is to focus on the issues that actually matter in the indictment. And my concern is that the witness summaries that are provided by the prosecution relate and include various issues that go, in our view, outside the scope of the indictment. And I will give you one example just to illustrate this point. The second witness intends, or at least according to the prosecution summary, the Rule 95.4 summary, I think it's the last paragraph, they intend to lead evidence in relation to incidents that took place well after the indictment period. We would suggest that this is not evidence that's relevant to this case. And to give you a concrete impact upon our cross-examination schedule, our cross-examination estimate, at present we've estimated 4 hours of cross-examination for that witness. I would suggest that if the prosecution was not allowed to lead evidence on that specific issue, we would cut that in half. That's something that relates specifically to an allegation that we say goes well beyond the scope of the indictment. And I think that probably, and again, this is just an example, relates to multiple different summaries and multiple different witnesses over the course of the 320. So unless there is that cooperation from the prosecution, or at least understanding that they will not lead evidence on that question, then we're in the situation where we have to prepare and we have to ensure that we're ready to cross-examine on that.
Have you discussed this issue?
I have not discussed this issue with the prosecution on this specific witness.
There again, we're getting closer to trial. If this is important to you, I would suggest you get on it and discuss it with the prosecution.
Understood, Your Honour, and maybe the prosecution could confirm. It's in their witness summary, so my understanding is that they intend to lead it if it's in their Rule 95.4 summary. So I would appreciate confirmation from the prosecution whether that's the case, but my understanding was that it is, and I would see no indication from them that they did not intend to lead that evidence.
I'm just suggesting a friendly conversation might be helpful.
And just on that point, Your Honour, what I would suggest is, therefore, if this is the case where we're requesting, obviously I think it's paragraph 118 of the Order on Conduct of Proceedings, or the annex on the Order of Conduct of Proceedings, is when we are objecting to part of a witness testimony, that we should do so, I think, at least a day in advance, and obviously provide notice to the other side. For issues like this, it may be more useful to do so a little bit more in advance of that, in the sense that if we're not going to hear evidence on that question, and therefore we're not going to cross-examine, we can update our estimate accordingly in advance and allow the prosecution to schedule the next witnesses earlier. The earlier we can get involved in some of these issues and actually cut back the scope of some witness testimony, I think the better for the proceedings as a whole.
Once again, maybe a phone call would also help.
Of course, Your Honour.
Mr. Ellis.
Good morning, Your Honours.
Good morning.
Your Honours, the time estimates that we've given were our best estimates at the time in the position that we were, which was that an enormous volume had been given at that time. even since the last hearing before Your Honours, we've had another 38 disclosure batches by my count. So there is more material coming to us and that we are still working through. The estimates that we've given are our best estimates at the moment. If we're able to reduce them, we will do so, but they're my best estimate at the moment.
Any particular concepts or ideas that you might have to shorten this matter?
Yes, the prosecution could call less witnesses, Your Honour. Okay. That's the core of it.
Thank you. Mr. Laws, anything you'd like to add to this?
Good morning, Your Honour. We have asked for 2 hours and 5 minutes as an outer estimate.
Can you cut that in half?
I don't think we can improve upon that, Your Honour. I'm sorry to say.
Thank you, Mr. Laws. Mr. Vasili, I cut you off a little bit. I was asking everybody if they had some idea that might be of help to us in deciding what to do here. And if you have nothing at this point, that's okay.
I think in reality, we've been banging the drum for 2 years now about the focus or lack of it in the prosecution case. We've reached a position where the trial chamber has taken a view that the prosecution must be given the scope to present its case in the order it wishes to do so and in the manner it wishes to do so. I'm not sure that anything short of a radical approach would make a significant difference. We've sought to cut our times to the bone to ensure that we're not contributing unnecessarily to the delay. But in practical terms, once we set off on this very lengthy journey, with the prosecution being given, despite the history, which is all on the record, of prosecution promises made and not fulfilled. Once we embark on this journey in that vein, I'm afraid I feel fairly certain there's going to come a time where the bench is going to think this is approaching a train crash. But I don't think I can help any more than I have done already, which is to warn for a very long time of this situation.
Thank you. You didn't get a complaint from us about the time that you scheduled, so we appreciate that. We will take your suggestions into account and your reasoning, and if we find that excessive material is being submitted by either party, or if repetitive questions are being asked, we will take what action we feel is necessary to complete this case in what we think is a reasonable time period. And I think you are all aware of the methods available to the panel under the provisions of our rules. We have said that we would start the case and observe the methods and the questioning used, but we will not hesitate to limit the SPO or the defense, both, on the time allocated to each. So be aware of that. We've done it before, and we will do it again if necessary.
Your Honor, may I just have one last notation on that? We will seriously go through and try to cut this down to the bare bone. We have a commitment to the court on that, with the understanding that if things happen during the course of that questioning, that we have some leeway in excess of that time. Not an extraordinary amount, but some understanding from the court that we've attempted to try to pare this down as much as we possibly could. But as Your Honor well knows, oftentimes that things happen in a courtroom that causes us to go a little bit further.
I assume, and we all up here assume, that you have all, most of you have padded this just a bit for your own protection and the protection of your clients. We understand that. We just want you to recognize it and recognize that we know that, and that we need to take what action we feel is necessary at the time, and we will. So thank you. Thank you for your submissions. Now I believe Judge Gaynor has a question, a further question in regard to this same issue. Go ahead, Judge Gaynor.
Thank you, Judge Smith. I have one question for the SPO, following up on your submissions earlier. And we acknowledge that you've said that all options are on the table for the SPO, and there are a great many measures the SPO can take to reduce the scope of its case, and you're assessing on an ongoing basis. what your position is. We acknowledge all of that. But as you yourself have acknowledged, the panel has its own power to step in and cut down the size of the SPO case. And you've referred to, for example, Rule 118, Subrule 1, A to E. My question to you is this: having heard the responses by the defence today, do you have any preference as to what steps might be most appropriate for the panel to take if it comes to the point where the panel is not satisfied with the steps that the SPO has taken? Which steps would the SPO prefer the panel to take to reduce the anticipated duration of the SPO case?
Thank you, Your Honor. As you could imagine, our first preference would be to not have that be necessary. But at the level of the question, assuming that the trial panel would be taking action, what would the action be? I think our preference would be if, as the trial goes along, if the trial panel, with the knowledge that it has of the case at that point, is able to affirmatively identify witnesses that it doesn't consider anymore to be necessary to hear, that would be a measure that would be meaningful information for us to make adjustments. And if the trial panel was to order that certain repetitive witnesses would be cut, knowing at that point in the trial what actually would be repetitive, we would say that would be the most efficient measure.
Thank you. Thank you, Judge Smith.
Okay, Judge Mitro has indicated he has some questions.
Thank you, Judge Smith. And the questions are for you, Mr. Halling, as well. I have a bit of sympathy, I have to say, for the submissions of the Selimi defense team, Mr. Roberts, in relation to the summaries of your witnesses which you've produced. And I'll just summarize the concern. We've received 3 different sets of summaries of the proposed evidence of your witness, I think, at the time of your pretrial brief, together with your list of 12 witnesses, and as part of your application under Rule 154. As Mr. Roberts has indicated, you've flagged up a number of issues in those summaries, and what is unclear, to me at least, is whether that's the evidence, A, you seek to rely upon, and or that you seek to elicit from your witness viva voce. There's another concern that was flagged up in some of the defense submissions. That's the fact that some of these witnesses offer in their statement evidence that might go, for instance, to acts and conduct of one or more of the accused, and that this is not flagged up in your summaries. So my understanding of the purpose of these summaries is to put both the panel on notice of what evidence you intend to rely upon for each of the witnesses, and as pointed out by Mr. Roberts, I think importantly as well to put the defense on notice of what you plan to rely upon so that they can make preparations accordingly. Now, when we have a summary, for instance, that doesn't reflect evidence of acts and conduct of a witness, whereas we know that in his or her statement that witness offers that evidence, are we to infer that you are not seeking to rely on that evidence, or that your summary is incomplete, if I may put it that way?
Yes. Rather than calling it incomplete, maybe it was rather that the summary, just by nature of being a summary, generalizes a very long interview of a witness into a small portion. The sympathy that Your Honor stated at the beginning of that is very apparent in Your Honor's decision on Friday. And in the Rule 154 decision at paragraph 29, there is clear guidance on this very point, and we understand that direction to be of general applicability. So when we are dealing with evidence of the acts and conduct of the accused, we're going to proceed in the manner specified in that paragraph.
I'm grateful for the indication, and of course a summary has to remain a summary, so we're not expecting of you to tell us what we know from the statement, but what is very important, I think, both to us again and certainly to the defense and victims' counsel, is we need to understand what part of a witness evidence you intend to rely upon, so that everyone is on the same page. But I'm taking reassurance from your words. The second question is really about the same issue. We've received indications from you, and that's your filing of 1st February 2023. It's F01243. That's your list of the first 12 witnesses. And as you know, of course, you've listed a number of exhibits which you link to each and every one of these witnesses. Some of them have been offered and now have been admitted as associated exhibit under 154. What we would like to know is what you plan to do with the others. And again, with the same attempt or intention in mind, which is to enable us to understand what's coming our way with each witnesses and to enable the defense to know what exhibits you plan to use with each witnesses. So in other words, what of the non-associated exhibits? Are you going to lead them all with each of these witnesses?
No, we're not going to lead them all. This goes to the remarks that I was saying earlier, that this is also a topic where we are going to be revisiting and making reassessments as information develops. And indeed, there may be situations where already admitted exhibits need to be shown to a witness in order to contextualize them or to present further information. And there's going to be exhibits, even if they haven't been admitted already, are going to be unnecessary in the overall scope of the proceedings. Not everything in F01243 is necessarily going to be tendered. And I mean, one easy example, it's not exhibits, but prior statements of fully live witnesses are listed in that filing. We don't intend to tender them. But as we make these adjustments, we have our final presentation queue that we are required to provide in accordance with the conduct of proceedings deadline. And if in the course of examining a witness, there's ever any question as to whether a specific document is to be shown or tendered, we can answer.
Well, I'm grateful, and I think I can indicate that the earlier you do that, at least in terms of informing the defense, the better, so that they are able to accelerate their preparation.
Understood.
And I'll ask you my third issue before turning to the defense, and that has to do with a specific document that you offered as part of your bar table application, filing F01268, and the document has an ERN SPOE 00232092 to 094. And it's in Annex 2 of that filing I've just mentioned under number 17A. And we would like to ensure that we understand what you are offering this document for. Because the English version, as we have it, is made up of one sentence only, and it's in fact an incomplete sentence. It reads, there have been more than 2 months that fighting in the first operational zones, ... Now we also have an Albanian version that contains that sentence, but also a much longer piece of information. And in the explanation you give for that document, in the annex I've mentioned, you seem to be relying upon that sentence only, the one I've just read. So are you offering the entire document as in the Albanian version? Are you offering the English version, that one sentence, incomplete as it is? And if the latter, what are you saying is the relevance and the probative value of that? Is it merely corroborative, or is it something substantive we should find in there?
Eventually, all the contents of this document are going to be tendered, Your Honor, but in order to fully answer the question, I should maybe take a step back and explain the context of this particular document. The last 2 pages that Your Honor is identifying in the document are found in multiple versions at Jakub Krasnici's house. This is where these materials were taken. The pages in the filing identified by the trial panel are a clean digital version. There is also a same version of that document found at his house that has handwritten edits on it. And this is at ERN SPO E00225101 00225-103. And that's the document that had the English translation made. So there's an ET of these pages in that document. As Your Honor mentioned, the first page, it's just one line, but it's the beginning of a draft of what becomes KLA Communicate 53. And this, to us, finding it in his house and what that says, further supports Krasniqi's authorship over that communique and other communiques like it. As you could see from our bar table filing, we were trying to group all the communique evidence together in that filing. And so that meant that the first page was of particular relevance to that filing, but the latter two pages, which are media documents, they are intended for a future bar table motion. And when we file that future bar table motion, we would tender those pages with English translation.
Thank you, that was clear. Counsel for Mr. Thaçi, anything on any of the three issues?
On the issue of Communique 53, it was a mystery to us as well, given it wasn't pieced together with anything else as to what the relevance of that document happens to be. We have some degree of illumination based on the reference to this other document, and we'll have to go back and take a look at that issue. Again, my instinct was along the lines that that the court obviously had. What's the pertinence of this? I don't want to speak that at this point I would have argued to you relevance, but I honestly need to go back and look at the other documents before I speak. But I do think, if I can go back to your initial issue on particular items, it is still a mystery to many of us exactly what in the Rule 54 information the prosecution is expecting us to pay attention to and what they are relying on. And it highlights the difficulty of wending our way through all of this information and their procedure of not only putting a witness statement, but all of these other ancillary pieces of information. It is acceptable, Judge, I shouldn't say acceptable, it is you can handle 50-page statement or something along those lines, but these are multiple statements of hundreds and hundreds of pages at a time. And while I do not intend to dampen the court's enthusiasm on cutting this back, there are some witnesses that are coming where there are hundreds, almost 1,000 pages of Rule 154 information. And without some direction along the lines that I think Rule 154 and our prior iteration 92 ter envisioned for both the court and the defense, that we are relying on these particular issues in what this person has said, we are left to drift through hundreds of pages of transcripts to divine for ourselves what we think is important, when it looks like that maybe the prosecution hasn't culled that down themselves. I think we've highlighted this difficulty before, Judge Matrol, but it still exists.
Thank you. Mr. Vesely. Mr. Roberts.
Sorry, just trying to decide amongst ourselves who speaks first. My only submission is in relation to the summaries, and that follows on from what I mentioned earlier and your questions to the prosecution. We are concerned if the prosecution attempts to lead anything beyond the summaries. And we will put the prosecution on notice, and obviously the trial panel on notice as well, that if we believe that evidence falls outside the scope of those summaries, we will contest it. And we'll do so as early as we can. And following on from the President's suggestion, I've already emailed the prosecution just to verify exactly whether they will be leading the evidence I referred to earlier in relation to the second witness. But there, as we all know from proceedings at the ICTY and other courts, there are, unless a lot of care is taken, extensive discussions about whether evidence led is within the summary or not. So I think the prosecution does have to be very careful and very clear as to why it is. And if anything falls outside that scope, they would need to notify the defence and the chamber well in advance. And I would suggest seek authorization to lead that evidence, because the scope of the case, as I understand it, is set out by those summaries. And that's the scope of notice of the prosecution case. Now, if they achieve, or if they have other, if they seek to present other evidence that's either newly identified or which was not included in those original summaries, then I would believe authorization from the chamber should be sought. Thank you.
Thank you, Mr. Roberts. And I will say nothing that you should not take as an agreement or disagreement with anything you are saying, but we note your your submissions on that. And as you will have seen, I hope, from your decision of last week, we've already taken steps to ensure that you get proper notice of what evidence the prosecution intends to lead, at least in as far as 154 witnesses are concerned. But thank you. Mr. Ellis?
Your Honour, on the issue of these summaries, we share the perception that there is a real problem here with the way in which summaries have been prepared. If I can give one example, that would be witness 4147. The witness summary prepared by the prosecution doesn't mention my client at all, but in the witness statement of that witness, so not an interview transcript going over hundreds of pages, but a statement, my client's name appears 11 times. That would seem to us to go beyond the simple process of summarising, and therefore we would support the position adopted by Mr. Roberts. But if I may, I would say the position is even clearer with respect to those 154 witnesses who've been addressed in recent filings. Because, of course, Your Honour's order, the third oral order at the hearing on the 16th of December, was for the prosecution to identify the issues, facts and circumstances under which the witnesses will be examined. The prosecution dealt with that in filing 1262. The summaries that appeared for some of the witnesses in that filing were significantly shorter than summaries that had been provided earlier. And our clear understanding is therefore that in drafting the summary for that specific purpose in response to Your Honour's specific order, the prosecution was delimiting what questions it intended to ask about. And so if matters are raised outside that, we would certainly be joining the objection. Very briefly on the issue of document SPOE 232092, Your Honours, our response to the bar table motion is coming tomorrow. We will be addressing that document and others in full. I will simply say for the record that producing a single line proves nothing. It doesn't prove authorship, and it certainly doesn't prove involvement in drafting, unless one knows when the document was produced.
Thank you, Mr. Ellis. Mr. Laws, anything?
Nothing from us, thank you.
Thank you.
Yeah.
Mr. Michetic.
Yes, sorry. Very briefly, if I could just be heard on Judge Gaynor's question, actually. And in response to the SPO, we just wanted to note the SPO's proposal under what they would prefer under Rule 18 would be problematic in our view, because I think it would, for the panel to tell the prosecution what witnesses it no longer needs to hear, I think would require some deliberations among you about what has been proven beyond reasonable doubt, or otherwise some deliberation about what facts have been established so that you don't need to hear witnesses about it anymore, which I think is a problematic course for the trial panel to take for reasons that I probably don't need to explain to you. So on the other hand, if they're referring to things that perhaps are not in dispute any longer, that's something I think that the parties inter partes could approach the panel about, not having to hear witnesses because the parties no longer dispute them. But I think we do reserve our position about the panel engaging in that type of assessment of the evidence before the conclusion of the proceedings. Thank you.
Thank you.
All right, Judge Gaynor has indicated he has a question for Victims' Counsel. Judge Gaynor.
Thank you, Judge Smith. Yes, I have one question for Victims' Counsel concerning the filing F01285, which is the Victims' Counsel's further notification of a wish to cross-examine witnesses, filed on the 13th of February 2023. And in that notification, you've indicated some matters that you'd like to question a particular witness about. With the leave of the panel, you submit that those questions are matters of legitimate interest to the victims participating in the proceedings in seeking to establish the truth about what happened to them. In addition, you add that these matters will only be addressed, if not already covered in full, by the SPO's direct examination of that witness. So my questions to you are this. First, whether you have discussed with the SPO if the SPO intends to question the witness about the matters you have identified, And second, whether you intend to liaise with the SPO in respect of similar situations in the future. Mr. Laws.
Thank you, Your Honour. Yes, the answer is yes, we have liaised with the prosecution, and yes, I'm confident that we have an understanding about the approach that both of us will be taking, and we will ensure there's no duplication of questioning in relation to these topics. And in relation to the supplementary question, yes, it will be our intention to liaise with the SPO when issues of this kind arise in the future.
So would you like the panel to issue its decision on your request to put those questions to that witness at the conclusion of the SPO's direct examination, or when exactly?
Yes. Yes, that would seem to us to be the appropriate moment at which to make a final decision, because it'll only be at that stage that we can be completely clear that everything we want to ask has been asked. And, of course, the SPO have many more issues to deal with this witness than we do.
Very well. Well, thank you. Well, we accept your proposal for how you want to proceed, and we would encourage you and direct you to follow the same approach, and in advance of any future notifications of questions that you wish to put to witnesses, which might overlap with the SPO's direct examination, could we ask you to liaise with the SPO beforehand to ascertain whether the SPO indeed intends to question the witness about the same matters?
Your Honour, we will.
Thank you. That's all. Thank you, Presiding Judge.
Thank you, Judge Gaynor. Judge Metro has a question or questions for the defense. Judge Metro, please.
Thank you, Judge Smith. And it's probably for all four defense teams. We wish to make sure we understand your case or cases in relation to a pretty critical issue in the case, which is that part of your case which you have put forward, and I will try to summarize it in a moment, but in relation to the role, functions, and power of the general staff of the KLA. We understand the prosecution case to be, in a nutshell, that your clients were all members of the general staff, and that the general staff had important and critical operational powers and responsibilities in relation to a number of issues, discipline, appointment, and so on and so forth. But the focus of my question is really about how we should understand the defense case in relation to this very issue, and for that purpose, we come through your pre-trial brief, and there seems to be, and I don't want to put words in anyone's mouth, but there seems to be a common thread through all four briefs, and I want to know whether that understanding is correct or not, and offer you an opportunity to set the record on this. But the understanding from your brief is that the general staff had no or little control over what was happening on the ground, that it had no or limited operational powers, that it had no or little commanding functions over the operational zones, and that the regulations and communiques which it issues, or which we are told it issued, were mostly aspirational. And in a nutshell, we understand your case to be that the operational and command decisions that are relevant to this case were made either at the local level or at the operational zone level rather than at the general staff level. Is that how we should understand your case or cases, if there are differences, or is that summary a fair one?
That is a very fair summary, Your Honor. That is reflective of the evidence that will be developed throughout, starting with the prosecutor's own witnesses, who will describe for you the chain of command within the KLA, certainly during 98 and 99, being chaotic, being broken down, being brigades totally washed away. Yes, that is in sum what our evidence would be, and not only reflected by the KLA members that the SPO intends to put on the stand, but likewise their independent witnesses that they are also going to put on the stand that talk about in February of '99 the virtually independent regional military authority. And then again in March of 1999, that same SPO witness that who noted that the efforts to bring operative zone commanders, now this is March of '99, the efforts to bring operative zone commanders under the umbrella of the General Staff have been only partially successful, as the zone commanders clearly retain operational independence. And and I'm sure your honors have seen this, which is the letter from the United States State Department to the Foreign Affairs Committee in May of 1999, where Ms. Larkin, Assistant Secretary of the Legislative Affairs, notes that there's no political structure in Kosovo or effective command and control of the KLA. So, in addition to supplementing the concise analysis that Your Honor has put forth, which is our position, it is also reflective in the evidence to be advanced by the SPO's witnesses themselves.
Thank you, Mr. Kehoe. Mr. Emerson?
Your Honours will find the Vasili defence case as to the role of the General Staff set out, I hope, clearly and explicitly between paragraphs 7 and 21 of the Vasili pre-trial brief. And if I can just highlight really one section where paragraphs 8 and 9 we point out that in attempting to discharge the burden of proving joint criminal enterprise, the SPO has misunderstood or mischaracterized the role of the General Staff within the emerging KLA, wrongly describing the KLA as a top-down organization that was operationally controlled by the General Staff at all relevant times, and that is to be found in the relevant passages of the pre-trial brief for the SPO. We go on, however, to trial, so it's not just a question of what the defence case is here. Two trial chambers of the ICTY have held on very much the same body of evidence that the so-called General Staff was comprised of a disparate group of individuals with no defined headquarters, who did not even know each other, all of them, or necessarily know who the other members of the General Staff were at any time, did not communicate with each other for the same reason all of the time, seldom if ever met, and were not always present in Kosovo. In short, as we point out, the findings of the ICTY in the Limai and Haradinaj cases was that this body, such as it was not operating as a General Staff in any conventional sense of that term. And one will see in the Limai judgment the reason for that, and this is important as the trial chamber begins to hear evidence. At paragraph 132 of the Limai judgment, the court says, the members of the General Staff did not meet regularly because of the security situation and identified themselves not by their names but by numbers for the same reason. In these circumstances, it is no surprise that the organizational structure and the hierarchy of the KLA were confusing or not known to outside observers, and that to some this suggested a state of confusion. In the Haradinaj judgment on the same issues, paragraphs 20 and 21, the court, this is the second Haradinaj trial, the court said at 20, the KLA General Staff in Kosovo did not have a single location where it was based in 1998. The members would move around for security reasons and usually independently of each other. And the judgment refers to the evidence of John Crosland, who was at the time the British Defence Attaché to the Republic of Yugoslavia in Belgrade, so the Serbian authorities, and goes on at paragraph 21. The Chamber heard from Colonel Crosland that while the KLA was organised to call the body at the top of the the General Staff was misleading. He did not think that the General Staff had effective control over the KLA. Colonel Crosland concluded that there was not a great deal of coordination between the zones and the General Staff. The General Staff would compile political statements, communiques, and give interviews, and this is interviews to the media and international media, which would set out strategy and political opinions of the KLA and provide an overview of fighting that were occurring. But as the evidence and the findings of the court made clear, did not have effective control over events on the ground. Now, the only part of the summary that Your Honour just set out that I'm not disagreeing with it at all, but it just needs to be nuanced in the last part of it. I think Your Honour's inference from that was that the defence case is that such strategic operations as might have occurred on the ground would have been authorised at a local or regional zone level. As we shall see, these zones didn't come into existence until the middle of the summer of 1998, one or two, and then gradually over time, zones were declared. Zone commanders were not answerable to the General Staff. It's absolutely clear, and all the evidence that you'll hear will make that clear. There is simply no line of command of the sort that you would envisage in a conventional armed forces. Calling yourselves the General Staff is a bit like the gentleman who was appointed in the Dukajin zone in June 1998 to be the KLA's head of chemical and biological warfare preparation, or the head of anti-tank brigade. There was no anti-tank brigade. There was no chemical and biological warfare preparation unit. People gave themselves titles in order to create the impression that there was more going on by way of organisation than there was. So any of the assumptions that any trial chamber might naturally bring to bear in relation to somebody calling themselves a member of the General Staff of what is a nascent organisation made up of farmers and workers gathering arms, obviously those assumptions will not carry any weight, or if they do, they will soon be exposed as false during the course of the evidence. That is something we can say with complete confidence, because the trial chambers who have looked at it in the ICTY in some detail over years of cumulative evidence have all come to that conclusion. And so the summary is correct, but it's not just a summary of a defence case, it's a summary of the facts and of the way in which they've been found. So the onus is on the SPO to prove that those judicial findings, which we will invite you to take judicial notice of, are wrong. And they're wrong because those courts didn't hear some key piece of evidence that will show they're wrong, that the prosecution now intends to put before you. But let's be clear, if there is such a piece of evidence that the prosecution intends to put before you, they haven't identified it in their pre-trial brief or in any of the material that they've served so far. So it would be surprising if it were to emerge at this late stage. So the only remaining nuance is, does it follow that all of the crimes on the indictment were authorised at zone level? No, it certainly doesn't, because some of them will have been spontaneous crimes committed by individuals on the ground. Some of them will have been scores being settled or individual so-called members of the KLA. I mean, just to be clear what we mean by a member of the KLA, obviously it will be a Kosovar Albanian who maybe follows one group at one time, another group at another time, is a farmer by day, a fighter by night. as has often been said by one of the zone commanders, I was the commander of those who on any given day chose to follow me. This is not an army that you are discussing. This is a spontaneous and encouraged response from village defence units across Kosovo to what they perceived, probably rightly, to be a planned genocide, and what they perceived, definitely rightly, to be an organised campaign of ethnic cleansing, crimes against humanity designed to drive them out of the country. So that's why I was saying at the beginning, we don't want to get, I know, into the Serbian side of things, but it is very important in understanding the inferences to be drawn from the evidence that you will hear.
It is helpful. Thank you, Mr. Emerson. Mr. Roberts?
In simple terms, yes, Your Honour. Your summary, your concise summary is our position. It's our position set out in paragraphs 89 to 95. It's supplement of our pre-trial brief, sorry. It's supplemented, obviously, by submissions of my colleagues, with which we fully agree. But at this stage, I don't feel there's more that I can add. But obviously, if you have any questions, please feel free.
Less is more, we told Mr. Roberts. Mr.
Apparently
Ellis?
so, Your Honour. Thank you.
Your Honour, I will heed that guidance. I have nothing further to add to our pre-trial brief and the submissions already made.
Thank you, Mr. Ellis. And I'm not inviting the prosecution to litigate your entire case, but if there's something you feel you should indicate at this stage, Mr. Halling.
Thank you, Your Honour. I'll be brief. From March 1998 to September 1999, the KLA was never as organized as a developed Western military force, like the one in the United States. They become more organized over time. Nor were they ever perfectly organized, with every single order and procedure followed every single time in the exact same way. But what the evidence will show, including collections of evidence like seized materials, not before the ICTY, is the consolidation of an existing and functioning hierarchy. The KLA General Staff had control over KLA units, but the way in which it exercised that control changed over time. Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi were all members of the General Staff throughout the indictment period. They were all authorities whose strategies and directives were implemented, including the common criminal purpose charged. Your Honors accurately summarized our position on the General Staff, made explicit in the indictment and in the pretrial brief, and we're looking forward to talking about it further on April 3rd.
Thank you, Mr. Halling.
Without taking any further time, it is right to point out that the premise of that submission, that Mr. Vasili certainly was a member of the General Staff throughout the indictment period, is fundamentally misconceived, as we spelt out in our pre-trial brief. He wasn't a member of the General Staff from the spring of 1999.
Thank you, Mr. Emerson. Thank you, Judge Smith.
Thank you, Judge Mitro. Now let us move to some questions in respect of the defense of self-defense raised by the Thaçi defense. Just for reminder's sake, on the 20th of February, the defense for Hashim Thaçi filed a notice of defense on behalf of the accused. Therein, the Thaçi defense gave notice of Mr. Thaçi's intention to raise the defense of self-defense. To fully understand this filing, the panel would like to ask some questions. They're general questions. I know you wanted to do a PowerPoint. We don't have any fundamental objection to a PowerPoint. We just didn't think it was appropriate today for this particular type of status conference. If you want to raise that for opening or for closing, just do it in advance in writing so that we know what you're doing. Turning to the first question, which I will address to defense counsel for Mr. Thaçi, I take it, Mr. Misetich, you will be doing the response.
Yes, Mr. President.
The panel notes that your client is charged with 6 counts of crimes against humanity and 4 counts of war crimes. Therefore, can I clarify if your client is pleading the defense of self-defense against all 10 charges against him?
Your Honor, the answer is, in light of the JCE allegation and the fact that all of the crimes are charged, even if through JCE 3, then the answer is yes. Because even if they were only to prove one of the crimes alleged as part of the JCE 1, then all of them would be JCE 3 crimes, or at least as alleged, as pled in the indictment, and therefore, yes, they're all related.
So following on from this question.
I can't hear you.
Got to push the button. Following on from this question, then, by pleading guilty, pleading the defense of self-defense, you are claiming that the self-defense excludes criminal responsibility, for example, the crime of arbitrary arrest and detention, inhumane acts, cruel treatment, torture, enforced disappearance, murder. In effect, you're saying that this is justified by the self-defense.
So, not quite, I think, in the way you're posing the question, but if I may have a few minutes to explain.
A few.
Okay. We're particularly concerned with count 3. So it's the unlawful arrest and detention charge. There are 34 paragraphs in the indictment that charge, and this is paragraph 61 to 95, that charge as a crime arrest and detention without due process of law. Full stop. So there's no need, according to the prosecution, to allege any physical or mental additional mistreatment other than the arrest and detention without due process of law. That's 34 paragraphs. Is going to be a lot of ground to cover at trial. And that allegation is a JCE 1 crime as pled in the indictment. So the first step is to say, I think the prosecution case will be, if they prove unlawful detention, arrest and detention without due process of law, then they will argue, we anticipate, that even if they didn't do anything else, that a possible consequence of the unlawful arrest and detention was that people would be tortured, killed, mistreated, etc., so they're liable for the whole thing. So the answer to your question is a little bit more complicated in the sense that, yes, the defense applies to the count 3, and I'll explain why in a second, but then it also, by necessity, applies to anything that would flow from that count 3, which would be the JCE 3 crimes. Now, why is it particularly relevant to count 3? There are a lot of issues that you're going to be asked to address in this case that I think are issues of first impression in international law. And one of the things we intend to raise is self-defense, because there are two primary questions that are unanswered at the moment by the SPO. One is, we have a situation here where we have a non-state actor in a non-international armed conflict. So a non-state actor, the first question that the prosecution hasn't taken a position on in this case is it the SPO's position that the KLA had no legal authority at all, given that they were a non-state actor under Serbian or Yugoslav law at the time, to detain anybody? In which case, is it the SPO's position that they didn't have the authority to detain under Yugoslav and Serbian law, and therefore any detention by the KLA is per se without due process of law and arbitrary? That's the first question. Second question is, or do they say, do they acknowledge and concede that if they didn't have it under domestic law, there was a right in a non-international armed conflict by a non-state actor to detain under international law? They haven't taken a position on that point. But let's assume, for the sake of argument, that they concede that there is a power to detain by a non-state actor in a non-international armed conflict. Then it takes us to the next question, which is, and this is discussed in the Mustafa trial judgment, but is also discussed by the appeals panel in this very case, which I'll get to in a second, which is, what are the procedural safeguards that a non-state actor in a non-international armed conflict must provide to people who are in detention? So the factual circumstances of this case are that the KLA, at the time of the events here, is opposed to the state. So when we talk about due process of law, the traditional guarantees of due process are Article 14 of the International Covenant on Civil and Political Rights, Article 6 of the European Convention on Human Rights, both of which talk about a person's fundamental rights to a fair trial and to be tried by a court established by law. Okay? So the question for the prosecution here is, if they concede that there was a power to detain by the KLA, but they argue that they didn't provide procedural safeguards, including due process of law, how was the KLA to provide due process of law as a non-state actor? Is it their case that the KLA was supposed to set up ad hoc courts? If so, which law were those courts supposed to be applying? Or is it their case that the KLA was supposed to take detainees to Serbian courts to be reviewed, to have their conditions of detention reviewed by Serbian judges? Which law applies, according to the SPO? Are the conditions of detention to be reviewed by, in accordance with Serbian law? In which case, if a Serbian, let's say, combatant is detained, is a judge to assess whether under Serbian law that Serbian combatant should be detained, or is some other law applicable? All of these questions are issues that are going to be raised, but I draw the trial panel's attention to the appeals panel's decision in this case. If I can find it. This is the appeals panel decision on appeals against the decision on motions challenging the jurisdiction of the specialist chambers, 23 December 2021, paragraph 95. And it says, quote, "The panel will first turn to address Vaseli's submissions regarding the legal bases of detention and the pretrial judge's finding that any form of deprivation of liberty in non-international armed conflict was arbitrary under IHL. At the outset, the panel agrees with the defense that the fact that IHL does not explicitly provide for authorization to detain in non-international armed conflict does not necessarily mean that such conduct is prohibited. As such, the panel is of the view that this would not render any form of deprivation of liberty arbitrary under IHL. In addition, and as acknowledged by the pretrial judge, there might be other sources besides IHL that could provide for such legal bases." Now, one of our arguments, not exclusive, but one of the arguments that we will raise and that we were required to disclose under the rule, which is why we disclosed it now, is that the right of self-defense, first of all, under Serbian law, gave the KLA the right to detain. And I'm referring specifically to Article 9 of the 1976 Yugoslav Criminal Code, which is the defense of necessity. And Article 9, Article 9, paragraph 1, is an act committed in necessary defense is not considered a criminal act. So, to address an argument that the SPO made earlier, I think they were putting the cart before the horse to say, for example, torture is forbidden under international law, and therefore using torture as an action of self-defense is prohibited, is not allowed. You can't invoke self-defense to justify torture. We agree with that proposition. The question, however, is the detention unlawful in the first place? Is it a crime in the first place if you're acting in self-defense? And so our position is, first of all, under Article 9 of the 1976 Yugoslav Code, you can detain, and as the appeals panel itself said, there may be other sources that allow the KLA to detain, and we believe one of those sources is the right of self-defense, also under international law. Secondly, on the issue of what types of procedural safeguards should a non-state actor in a non-international armed conflict under attack and acting in self-defense provide? Is it the case that someone under attack in necessary self-defense who takes an action of detention can't do that before they've set up ad hoc courts to make assessments of detention? We would argue that self-defense is something that needs to be considered in that context as well, in context of what types of procedural safeguards need to be provided. So that's an additional ground. We cite two more things, and I'll sit down. The Kordich and Cherkez trial chamber said, quote, any argument raising self-defense must be assessed on its own facts and in the specific circumstances relating to each charge. That's paragraph 452 of the Kordich and Cherkez trial judgment, and we agree with that. These are issues that'll have to be fully litigated at trial, and you'll have to assess and hear arguments as to the applicability of this. But many of these questions that we're raising are issues that I think are going to be issues of first impression for you to opine on and give your judgment on. And one final point, which is not limited to the issue of self-defense, but generally on the issue of Serbian crimes and Serbian offensives and things along that nature, and this is related also to Judge Matro's question earlier about effective control. All of the questions of the conduct of Serbian forces is related to the question of effective control, and we would draw your attention to the Oric case, the case of Nasser Oric in Srebrenica, paragraph 503 and 504 of the Oric trial judgment, and I quote, it said, moreover, taking into account the chaotic circumstances prevailing during the early months of the Srebrenica siege, and the trial chamber simply cannot come to the conclusion that the Srebrenica Armed Forces staff had effective control over the Srebrenica military police. And then paragraph 504, therefore the trial chamber is not satisfied beyond reasonable doubt that the accused, as commander of the Srebrenica Armed Forces staff, exercised effective control over the Srebrenica military police. So the chaotic circumstances in Srebrenica created by the Serbian siege of Srebrenica was directly relevant to the issue of whether the accused in that case had effective control for purposes of command responsibility. And the same situation applies here. We are going to argue that the chaotic circumstances created both by various Serb offensives, I should say, particularly in the summer of 1998, but also in March 1999, had a direct impact on the effective control question of the general staff, generally, of the accused here specifically, and the issue of Serbian crimes as well is related to that question. So I'm sorry for the lengthy response, Your Honor, but I think it needed to be discussed.
Okay. Assume for a moment that we will assume for a moment, for argument's sake, that the KLA could possibly take people into custody for their own protection. What's the duty of care after you take them into custody?
There are obviously certain minimum guarantees under IHL to. Of course not. That's my point. So I conceded that point in my presentation. You can't torture people. You can't kill people. You can't do certain things that are prohibited. So that's why I was trying to.
The problem is almost every crime-based event here is somebody who was taken into custody. It begins with somebody being taken into custody and ends with something else happening. And I'm struggling with the fact that, well, with those facts.
Well,
the fact that if bad things happen, KLA says, oh, no, since you charge us with JCE 3 or JCE 1, we don't get to discuss those matters. Self-defense takes it all out. I'm having a struggle with that.
I don't think I said.
Well, you indicated that in effect, the self-defense operated as to all of them because of the fact that there was the JCE type charge. That's the way you led off.
So I guess there's maybe a misunderstanding.
Well, I probably didn't understand you fully.
Okay.
That's entirely possible.
If you're looking at just the charge of torture, for example, you bring in a case of, person X was tortured and that's the charge, then I don't see a circumstance where we're going to argue that, okay, they were tortured, but they were tortured in self-defense. My point was that one of the charges could lead to applicability to all of the charges, and that one charge in particular or self-defense is relevant to that one charge in particular, and that is the count of unlawful detention.
Okay,
But it doesn't necessarily mean that independent of that count 3, we're going to be applying and justifying every action of everyone as justified by self-defense.
Okay, it only sounds like it.
No, no. It only relates to the liability to the extent that they try to use, they try to say that if you were responsible for unlawful detention, full stop, and I would also clarify, you say that people were unlawfully detained and then bad things happened. I don't think that's the case for 34 of the paragraphs in the indictment, right? Those 34 paragraphs just say, so-and-so was arrested or detained without due process of law. Full stop. That's the incident.
No, you're misunderstanding me now. I'm just saying that any person in this group that had something, let's say, just bad happen to them, torture, murder, mayhem of some sort, started out with an arrest. They were mostly taken into custody, and
Right.
then something happened.
Yes.
So I'm just struggling to understand. Your position is, in the event that we would deem the arrest and detention to be, or the detention alone, to be not objectionable, then the rest of them stand on their own then, right? They're not dependent on that unlawful arrest.
I think we're saying the same thing, but let me just clarify. We're not applying self-defense to the perpetrator who killed someone.
Yeah.
Okay, so we're not saying that that perpetrator's crime of murder was justified by self-defense. So,
I understand that.
Okay, and so all we're saying is, to the extent that our client specifically is being held responsible under JCE 3 for the actions of that person, if you were to find that he's responsible somehow because, and I will say that there is an allegation, and this is in particular paragraph, let me just find it. Paragraph 12 of the SPO brief. Here's I shouldn't say all, here's one of the allegations. The accused participated in the common criminal purpose through their awareness of the circumstances in which the policy against the opponents was being implemented, the absence of safeguards to prevent abuses. Right? So their mens rea is, if they know that there aren't courts to review detentions, right, then they're aware that there are circumstances that this policy is being implemented, and therefore they're in a JCE 1, and now we get to they're liable for, if somebody, without their knowledge, killed someone, tortured someone, et cetera, you're still liable for it. So our point is the applicability of self-defense, first as a source of authority to detain in the first place, is applicable here.
We will certainly study that and appreciate your candor. A couple of other questions, though, and this is more of a technical one. Are we in agreement that a defendant who pleads self-defense does bear the burden of what's been called establishing that there is sufficient evidence to require the issue to be litigated, and then the prosecution, of course, still has the burden of proving that there was not in self-defense, but you do have a burden to at least put enough evidence on to bring the matter to the attention of the panel. Is that correct?
That is correct, and that is
No argument?
Yes, we intend to do that, and I think it's related to the question of the Serbian offensives and the Serbian crimes that we've discussed earlier. That's part of why we're raising it, in addition to, it's a whole and apart, the issue of effective control.
Carefully about that.
As we've said in the past,
We don't want the case to become one of a prosecution of Serbian crimes. We do not want that to happen here.
we're defense lawyers, so we're not prosecuting anybody.
Okay,
But I will say that, if you look at the Orich trial and appeals judgments, you will see the relevance of the, in that context, the Serbian siege of Srebrenica and its effect on effective control, and we think there are many parallels, and we will actually ask you to draw the parallels in closing argument, and why the context of the Serbian offensives and crimes is relevant to these issues.
Coming to what I would call the substantive elements of the defense of self-defense, do we agree that according to Kordich, which you cited, that it must be shown that the accused acted reasonably to defend himself or others in this case? Is that correct? There's a reasonableness issue.
Yes, I don't think you can act unreasonably in self-defense, so yes.
The threat has to be imminent and unlawful,
Yes,
proportionate to the degree of danger.
yes.
In effect, am I wrong? In effect, you're pleading self-defense by proxy. That somebody else did the act, and that was the self-defense. And it's immuted to your client. Is that correct?
I'm not sure if that's quite the case, but yes, and to the extent that, and again, I'm going to use the example of the detentions. So were detentions reasonable? Was awareness that detentions had taken place reasonable? Right? Was it proportionate?
Proportionate.
Was it in response to direct harm? Let's take those one by one. If Mr. Thaçi is aware that commanders are detaining people who are war criminals, and I say that, and you'll hear evidence on this later, I'm just going to tease you with that for now. If they detain someone on the Serbian side who's a war criminal, a combatant on the other side, is it reasonable to do so? Is it proportionate to do so? We would say yes. Okay? So in that sense, we're not saying any action by the person who did the detaining is covered by self-defense. If, in addition to other bases that we will argue, but that's one of them, is that it's allowed under Serbian law, Article 9, you can detain the person, and it's allowed, and we will argue under international law, additional bases to detain people in those circumstances.
I appreciate the quote from Kordich. Unfortunately, you left the last sentence off of that particular paragraph that reads, "The trial chamber, however, would emphasize that military operations in self-defense do not provide a justification for serious violations of international humanitarian law."
I didn't leave it out. That's what I was addressing earlier. So whether it's a serious violation of international humanitarian law is the ultimate question.
Is the question. Yeah.
Right. So
and you've sufficiently told me how complicated that question is.
right. So my point is the detention a serious violation of international humanitarian law or not?
Okay.
Right.
All right. Thank you very much, Mr. Misitich.
Thank you.
I will certainly allow the defense to respond. Mr. Emerson, anything?
There is no doubt that the coming into existence of the Kosovo Liberation Army over 1998 and 99 as a collective of people fighting was in the broadest factual sense in order to defend themselves and their fellow countrymen against the Serbian onslaught. So that much is a key part of the context, without any doubt at all. We entirely endorse much of what Mr. Misitich has said about detention. It is our case, putting it perhaps a little more simply, that we will argue that it is not a violation of humanitarian law or a crime triable in this jurisdiction for a non-state armed group to detain somebody, for example, who is an enemy combatant, who is a civilian directly participating in hostilities, or who is, and this is one of the very difficult questions of degree you may have to consider, who is either a civilian DPH in that sense, or a suspected collaborator who may be passing targeting information to your enemy. Those factors, we say, are not crimes recognized under international law. And in a sense, the end result is the same, because we haven't specifically joined the self-defense invocation as a matter of law because of some of the complexities that you have raised. Namely, nobody would be suggesting that ill treatment amounting to a crime triable under the jurisdiction of this court could be answered with a plea of self-defense either by the individual or therefore by prosecution reasoning on a collective basis by those who are said to be the joint criminal enterprise that authorised it. So we would put the matter much, much more simply. Of course, the KLA was a self-defensive organisation, that much is clear. To the extent that the prosecution identifies the purposes of the JCE to be securing control over Kosovo territory against the Serbian attack, and there is language in the JCE description which may suggest that, then that obviously would not be a criminal intent. And I don't think, when pushed to it, the prosecution would say it was a criminal intent. The allegation is that it was an intent to do that by certain unlawful means. So the focus is simply on the unlawful means. And all we would say, putting it simply, and I think coming to much the same position, is for a non-state armed group in a defensive posture against a very significant attack, it cannot, either as a matter of law or as a matter of fact, be a crime for them to arrest and detain either enemy combatants or civilians directly participating in hostilities or intelligence agents, if you like, collaborators with the Serbian authorities. But the reason we haven't pleaded this as a self-defense is because my client's case is very, very clear, and I think it's the case in common with the other accused, which is that our submission is there was no such agreement or indeed control or direction from a top-down direction. If people did it, then we would say that cannot be categorised as a crime, and where they're shown to have done it, we say it cannot be categorised as a crime. But as our best reading of the prosecution's attempt to fix, for example, my client with criminal liability is to say, well, look, there were these things happening in different places. Yes, he wasn't involved in them and we can't connect him to them, but there's so many of them, or they happened at such a time, that there must have been a plan. Well, we deny there was any such plan to which Mr. Vasili was a party. It wasn't his function, as we'll show. He had nothing whatsoever to do with that side of matters, but you will still need to go through the process of deciding whether a conglomeration of acts around Kosovo over a 2-year period were criminal acts or not, before you can draw any inference about them contributing as a fundamental factual basis, as bricks in the wall for the prosecution's attempt to show the existence of a joint criminal enterprise. I hope that's just a rather different way of putting the same outcome.
Thank you, Mr. Emerson. Mr. Roberts, anything to add?
Very little, Your Honour. We obviously subscribe to both what Mr. Emerson and Mr. Misetic have already stated, and it's always a pleasure to listen to Mr. Misetic. I always feel more intelligent by osmosis. I would merely make one point. I think we subscribe more almost to the position that it is for the prosecution to prove the illegality, the arbitrariness of the detention, and so in terms of the burden falling on us, that's where we may be slightly different. It's a complicated area of law. I think just listening to Mr. Misetic and Your Honour, we can understand that, and this is something that will require detailed argument at some point over the course of trial. The one issue that may arise is the impact of Mr. Thaçi's notice on the other accused, and that is a question that I don't know the answer to, so it's always slightly dangerous to raise. But my understanding is that if proven, and if the elements are proven in relation to Mr. Thaçi and the facts are applicable to us, we would also benefit from the same. Again, I'm not entirely sure on that answer, but my understanding would be that that would be the case. But it's just something to raise in the context of that submission. Thank you.
Thank you, Mr. Roberts. Mr. Ellis?
Your Honour, again, I've got very little to add to what's gone before. Simply to say, firstly, that although Mr. Emerson and Mr. Misicic put the legal basis differently, we would see that the same factual material would likely be relevant on either analysis. And so we would oppose any restriction of introducing the facts that could support either position. And secondly, I do agree with Mr. Roberts that one difference between the two positions may be in where the burden of proof lies. We would subscribe to Mr. Emerson's description and say the burden remains on the prosecution.
Thank you, Mr. Ellis. Before we get to you, Mr. Halling, Judge Matreau had a question, I think, for the defense, and then we'll come back to you.
Well, unlike Mr. Roberts, I feel less intelligent after I've listened to you, Mr. Misicic. So I need to ask for a clarification on the way you articulate what you call the defense of self-defense. Just to summarize my understanding of the issue, at least on this, is the prosecution is alleging an unlawful and arbitrary sort of detention, including, as you said, for reasons of absence of due process of law. My understanding is that as an element, was demonstration of the actus reus of that offense, the prosecution will be required to show that there was, in fact, no legal basis for it. And if they were to succeed in demonstrating that, my understanding is that that's where potentially your defense of self-defense would become relevant in showing that something otherwise unlawful is rendered lawful by the existence of such a defense, assuming it applies, of course. I'm a bit confused, I have to say, in listening to your submission on that point, that you seem to suggest that the defense itself is the one that provides the basis for detention in the first place. Is that the way you present it to us?
No. So I inarticulately, obviously, tried to explain that we agree with you in your proposition there that they have to prove the absence of legality. But procedurally, here, we had a deadline that if we were going to raise self-defense, we had to make that filing in February, which we did. But by no means should you take anything I said here as exclusive of other issues that arise in this context, both in terms of what the prosecution has to prove and us in terms of other arguments we're going to raise as to why it was legal. But as a strictly a matter of procedure in giving the prosecution notice required under the rule of our intent to raise the issue, we provided the notice, and then things went off the rails a little when there was a filing challenging our notice, and now we're going into the back and forth of this issue. But these submissions are made exclusively as a result of our procedural obligations.
I'm not blaming you at all, Mr. Misicic, for the notice. Quite the contrary. It's most welcome, I think, in terms of putting everyone on notice of its existence. Where I'm a bit confused is in the suggestion, if I understand it properly, that self-defense as a defense would in effect operate, if I understand your submission correctly, as a legal basis authorizing detention. Is that the way we have to understand your approach to this issue? In other words, anyone claiming self-defense can raise the so-called defense of self-defense as a basis for the purpose of detention. Is that the way you articulate it?
Anyone claiming, I'm a little reluctant because I fear that we're not understanding each other, but let me phrase it this way. One of the things that we are raising is, if you look at it from the perspective of the applicable domestic law at the time, when could someone in the position of the KLA under Serbian law have legally detained a Serbian police officer or army member?
But that part, Mr. Misicic, I understand that that's part as I said, of what I understand to be the burden of the prosecution. What I don't understand is how, in this context, the defense of self-defense is helping you. Are you saying that it would provide a legal basis in case there would be no other that is applicable? My understanding of the defense of self-defense is it only becomes relevant if and when a crime has been established, right? Now, what I understand you to say...
I would say no, and this is why I was hoping to put a slide up so that you could read Article 9 of the Yugoslav Criminal Code for yourself. But the Yugoslav Criminal Code says if acting in self-defense, there is no crime, right? So if you read Article 9 of the SFRY 1976 Criminal Code, it says, subsection 1, an act committed in necessary defense is not considered a criminal act. So I wouldn't agree with you then that it only applies if the crime has been established. It's that the crime isn't established if self-defense is established.
Now I understand your position. Very briefly, the second thing that I want to ask you is your reliance on the Oric case, and I've had briefly the time to look at it. The findings of the trial chamber in that case appear to be that there was a failure on the part of the prosecution to demonstrate effective control by Mr. Oric in relation to the military police as a result of two considerations. One is what they called the chaotic circumstances at the beginning of the conflict around Srebrenica. The other one is, I think, the erratic behavior of Mr. Halilovic Mizret, the head of the military police. I saw no sign of Serbian crime in relation to the considerations that the trial chamber in that case took into consideration to come to that view. Is there another paragraph that you seek to rely upon?
I don't think I said Serbian crimes with respect to Oric, but I did say the siege of Srebrenica, and I don't have the paragraph numbers in front of me, but I believe the Oric trial judgment has a whole section that discusses the siege of Srebrenica as a factual matter. So in my submissions, I said the offensives, the Serbian offensives, particularly in the summer of '98 and in March of 1999, are going to be relevant as they were relevant in Oric. And we also believe that the crimes are relevant, both in terms of establishing the elements of self-defense, right? An impending harm that's threatened, right? And in terms of effective control. And those, because we believe the criminality, the expulsion of the Albanian population, both in the summer of 1998 and more massively in March of 1999, also had a direct impact on the effective control that the general staff could have.
Thank you.
Thank you, Mr. Misitic. Now, Mr. Helling. Oh, I'm sorry. One more question.
I have a couple more questions for Mr. Misitic, and that concerns your submissions about the duty of the KLA as a non-state actor to provide due process of law, and specifically in respect of your submissions about the duty of a non-state actor to establish courts of law. Now, is it your position that the KLA was or was not, under international law, obliged to establish courts of law? And my second question is any failure by the KLA to establish due process of law excused as a matter of law because they didn't have the power to do so, whether under Serbian or international law, or is it excused as a matter of material inability to do so due to the chaos of the conflict? So I can go through the two questions again if you wish me to, but the first question is simply this: do you accept that the KLA, as a non-state actor, was required under international law to establish courts
I don't think they were required to establish courts, because I don't think they had the legal authority at the time to establish courts established by law.
Under Serbian FRY law or international law?
Well, I don't know. I would have to be honest with you, I'd have to look into international law and the duty to establish courts under international law. Obviously, under domestic law, they didn't have the authority to establish courts established by law under Serbian law at the time.
And my second question goes to the failure to provide proper due process. And you've relied a lot on the circumstances prevailing in Srebrenica at the time that Orich was active. Are you arguing that any failure by the KLA to provide due process or to establish courts is excused due to the material inability to do so, which came about as a result of facing a militarily superior opponent and the chaos prevailing at that time in Kosovo?
Do you mind if I just interpolate at this point before Mr. Misitic seeks to answer that question? The entire issue of the duty of a non-state actor to establish potentially due process and courts is a matter on which there is very, very considerable discussion, learning and doubt. And we would respectfully submit that rather than have these matters, which are important and difficult, debated at this stage at the status conference, they be the subject of more detailed consideration in a written form. People watching this may see Mr. Misitic answer on the hoof on an issue which they may take to be a defence position. This is a very, very important question, and I think we will need to have it properly briefed, if I may respectfully say so, Judge Gaynor.
Mr. Misitic, I'd invite you to respond if you wish to do so.
Yeah, I do agree with Mr. Emerson that I think the question now would better properly be briefed, because the way you've asked the question is any failure, which I think we need to go case by case and see exactly what types of failures of due process we're talking about. I was trying to suggest earlier in my submissions that the issue is for the prosecution, not for us, to tell us their case first, right? So I think we've really put the cart before the horse at this point to say you haven't compelled them one time, not you specifically, but I mean, they haven't been compelled one time to state their position on this, right? Does the KLA have the power to detain in any circumstance? Yes or no? If so, on what legal basis could they detain? What types of due process does the prosecution say the KLA had to provide? Once they're on the record with their position, then I think it would be proper for the defense to respond to whatever their case is, right? But all we're trying to do here is just explain why we gave a notice of intent to invoke self-defense, right? I do agree with Mr. Emerson that it is an extremely complicated issue. There's a lot of writing about non-state actors establishing courts, et cetera. I don't think the case is actually, Mr. Emerson might correct me if I'm wrong, I don't think we have a legal judgment in a case that's decided the question, though. There is a lot of scholarly writing on it, but whether a non-state actor in a non-international armed conflict has a duty to establish ad hoc courts is a question that you'll have to address. In terms of the due process, one of the questions we're asking the prosecution to take the position is, can the KLA establish, or was the KLA required to establish courts established by law for purposes of Article 14 ICCPR and Article 6 ECHR? Could they do it? And if so, how could they do it? And is the failure to do it then something that was a violation?
Thank you, Mr. Misitic. Thank you, Judge Smith.
Thank you, Your Honor. I know we're getting to the 11 o'clock break soon. I'll be brief. This is a manufactured, complicated issue. This isn't self-defense, what's being described. If detention is not arbitrary, that would be a failure to meet the elements of the offense. it would not be a ground for excluding criminal responsibility. And whether or not the detention was arbitrary or not is completely independent from any allegations about Serbian crimes. Because that's really what this issue is about. No matter how chaotic the war is, you can't torture people, you can't kill people, there seems to be agreement, but you can't arbitrarily detain them either. The trial panel has set out clear limits on leading evidence of alleged Serbian crimes in this trial. The defense cannot raise a frivolous ground of excluding criminal responsibility as a vehicle to circumvent those limits. Thank you.
We will take a break for a half hour. We'll just call it 40 minutes. We'll be back here at 11. Oh, I'm sorry, Mr. Emerson, something.
Just before Your Honours do take the break, and given that the break might provide an opportunity to reflect on this matter, what has become clear in this conversation, I'm not addressing the self-defence issue, but the questions of arbitrary detention that arise from that. Now, I'm with great respect, inclined to agree that with the simple formulation put by the SPO that it is their obligation to prove arbitrary detention. But the word arbitrariness is one of the most difficult words, especially when it comes to detention, in international law to define. So, for example, whilst human rights law continues to apply during an armed conflict, as we know, the two systems of law map over one another and seek to avoid conflict. So when deciding whether a death is an arbitrary killing under Article 2 of the European Human Rights Convention, the reference is to humanitarian law. Any killing in a war, in a conflict which is in violation of humanitarian law, is arbitrary, which of course, in a situation where humanitarian law doesn't give you the meaning or the answer, is a circular situation. And we are in that situation as regards detention by a non-state armed group. So prosecution is not incorrect to say arbitrary detention is like torture or killing of a person detained, unlawful. The question is, how do you define arbitrary? And that is a really significant issue to have clarified before we set down, at least to know what the prosecution says. Arbitrary is almost a meaningless word. It means, there's no definition that will help you with what arbitrary means. You're going to have to answer the question by reference to principles of humanitarian law. And my suggestion would be for the bench to consider ordering an exchange, at least ordering the prosecution to define what it is they say are the limits of a non-state actor's ability to detain before it becomes arbitrary. And obviously we can talk about due process, but that's after the event. That's a separate set of questions which need to be asked and answered as well. Because maybe, let us say, the bench is persuaded that you can't detain somebody unless you've got a court system and an independent judge to release them if their reasonable suspicion of their involvement is not met. Well, we may not need to have a trial on that then, because there weren't any court systems in operation. So, I mean, with the greatest respect, it would help everybody, including the SPO, but certainly the bench, and immeasurably help the defence if we didn't start this trial not knowing what the target is that is going to emerge from the end of it, which must mean the onus is on the prosecution now to spell out in very clear terms what it means by arbitrary.
I'm sorry to take more time, but
Go ahead.
I just want to join Mr. Emerson and say, regrettably, and let me just say for the record, we're not manufacturing anything. Every argument we've made here is made to you in good faith because we think there are serious legal issues here that need to be addressed. It really, we talked all morning about streamlining the proceedings, cutting back time, getting to the heart of what it is that's in dispute between the parties. It really would help us to know what are we arguing about in terms of what is arbitrary, what does the SPO think is arbitrary, so that perhaps we don't need to lead a lot of evidence on a lot of the issues we've discussed today if they, for example, concede that the KLA had the power to detain. What constitutes due process if you have the right to detain? What is it specifically that didn't comply with due process? You know, were courts required, et cetera? I mean, maybe we can have inter-partes discussions on this point. I'd be happy to do it. But the more that we can narrow these issues, the more we can avoid taking up a lot of courtroom time, exploring things that ultimately in the end might not be in dispute. Thank you.
I do apologise, but may I just respectfully add that the discussion that's gone on this morning, those who find the conversation makes them feel less or more intelligent, the difficulty of those discussions illustrates exactly the point that I'm making. The Thaçi team comes to the same end result via a completely different route, which is the product of the fact that nobody in this courtroom knows what the target is, what has to be met, what arbitrary means, what are the rules of the game as far as that is concerned. And the onus, I think, has to be a written pleading, at least on what the two, supplementary to the pre-trial brief, at least on what the various sides agree and disagree, and that must begin with the prosecution. Because if we start this trial, not, as Your Honour has said, most of the charges on the indictment have gone through the gateway of a detention. We're going to spend potentially 6 years deciding, listening to all of that evidence about detention without knowing whether it's agreed that the detention is not unlawful, providing there was a reasonable ground for it, and so on. So I think we have to tackle that very, very quickly before
Thank
the
you,
trial
Mr. Emerson.
begins.
Anybody else?
Nothing further. Your Honor.
Okay, all right. We will take a break. Please be back at 11:30.
All rise. All rise.
Be seated, please.
Your Honour, may I just raise one question on...
Just a second. Go ahead.
May I just briefly raise a question on the translation of the transcript of this morning's proceedings. You'll recall that I challenged the SPO's assertion that Mr. Vasili was a member of the General Staff throughout the indictment period, and I pointed out that, in fact, he left the General Staff in the spring of 1999 on the establishment of the fresh arrangements for the government of Kosovo, future government of Kosovo. Apparently, although it appears correctly recorded on the English version of the transcript as me saying that he was not a member of the General Staff at any time after the spring period, it has appeared in the translation, so I'm assuming it was perhaps the translator misheard me, as he only became a member of the General Staff at that time. So it's the other way around from the translated transcript.
All right, the record will reflect that statement. The record should also reflect the fact that Mr. Vasili, for good reason, has left the Zoom and had filed a waiver as he's supposed to do, so there's no problem with that.
None at all.
I have one question, Mr. Helling, for you that is related to what we were just discussing. This is not a general discussion matter, it's just a question for you. I want to know if it's the SBO's position that you have a valid, that there is a valid legal basis under international law to detain in the circumstances of the dispute we are hearing?
I think that my answer to that question is yes, but just to clarify how I understood it. We do not ascribe to the absolutist view that Mr. Misicic was discussing, and that no KLA detention could ever be lawful under any circumstance. We do, however, believe that in accordance with international humanitarian law, the arbitrary detentions charged are in fact unlawful. We have on this point, if it is of assistance, fully ascribed to the applicable law and the elements of arbitrary detention set out in the confirmation decision, with no adjustments. And as to the question of the defense not having any awareness of our position, we put every single one of those legal propositions to the defense in a proposal for agreements of law last month, and they did not accept any of them. But that is our position on this point.
Once again, valid legal basis to detain. I'm not saying arbitrary, just to detain.
Yes, there can be a valid legal basis to detain.
Okay. Hopefully that helps frame the question a little better. You want to ask a question? Yeah, go ahead.
Mr. Helling, I was just wondering which or what legal basis would you say would entitle or would grant a non-state actor the right to detain people?
It may be better to answer the question in the inverse, because this is how it's done in the confirmation decision. This is from paragraph 94. The deprivation of liberty is without legal basis when it's justified neither by criminal proceedings nor by reasonable grounds to believe that security concerns make it absolutely necessary. The next paragraph specifies what some of those basic security safeguards are. So as you can see, it is not, there is room under international humanitarian law as reflected in the confirmation decision for there to be a valid legal basis. The citations at paragraph 94 are relevant on this point, and there's ICTY, Cordich is mentioned, also the ECCC. But this is our understanding of the legal elements of the offense and when it would be justified.
Thank you.
So we will move on then to the last few items that we are dealing with. Excuse me. Let's turn to the calendar for the case. I just want to review some of that just to make absolutely sure we're all on the same page. We do, as you all know, we intend to open the case on April 3rd at 9 a.m. The parties and participants are expected to keep to their allocated time for opening statements. In respect of the defense, any statements by the accused should also be within that same allocated time. And as a reminder, all parties and participants, the schedule for the opening statements is April 3rd, in all probability, and into April 4th, the opening statements by SPO, which is 5 hours. On the 4th of April, at 9 a.m., opening statement by either the remainder of the time allocated to the SBO or Victims' Counsel, who has estimated 45 minutes. Then the opening statement by the defense in the following order. The Thaçi defense is 3 hours maximum. The Vasily defense, 45 minutes maximum. On April 5th at 9 a.m., the Salimi defense, 1 hour maximum, followed by the Krasniqi defense of 1.5 hours. And finally, we might have questions by the panel. I will ask everyone to be flexible, to be ready to go with the next, when you are the next in line, in case somebody finishes early. We would also like to note the following. Counsel are cautioned to focus exclusively on matters relevant to the charges and to avoid irrelevant matters or statements of a political nature. The panel is hoping for clarity regarding the parties' respective cases and expects you to address these issues that are those issues that are the core of your respective cases and try to avoid as much as you can repeating what we already know from reading your pretrial briefs. We ask you not to interrupt the opening of the other parties or participants. Any comments by anybody? I'll start with Mr. Halling. Anything?
Nothing, Your Honor.
Nothing, Your Honor.
All right. Anything?
Nothing, Your Honor.
All right. I do want to stress that it would be extremely helpful to the interpreters and guarantee an exact and appropriate translation of your statements to get a copy of your statements to them ahead of time. And you can go through CMU for that purpose. We ask you for, if there were any other items that you wanted to bring up before our trial, which is now coming up quickly. And you, I believe the only people that, just the Thaçi defense and the Salimi defense supplied some items. I take it that, do you wish to be heard on these? I don't see any kind of a formal motion filed on anything.
I can certainly do that, Judge. I try to involve myself into inter-parties discussions on that. I thought that this would be an easy way to short-circuit the issue, just to bring it to the court's attention that we are looking to get benefits to witnesses who have been transferred to third countries. That would incorporate payments, benefits, assistance to the witness and others, and this involves two witnesses out of the first 12 and then the third witness. It goes to, of course, the case law is pretty clear. It goes to the credibility of those witnesses. And in the system that you and I are used to, Judge, it's the Giglio material. I mean, it's any incentives that a witness has that could go to his or her credibility.
I see that. I see what you've stated, and I'm suggesting that you file something. If you wish to have something definitive, that you file a written motion. We will answer it in short order. I will say on the Salimi, do you have anything else?
No, just on that. That's fine, Judge.
As far as the Salimi defense, I will say that the courtroom seating is going to remain as it is. I understand you've brought this up before. Security is a very important issue for us, and we are advised that this is a secure method of handling this situation. If you need to have a moment to go talk with your client, you certainly will be granted that, and that's been our practice. You also are granted some time, which we've tried to enhance during the day for conversations with your client during breaks. Do you have anything else?
No, Your Honor, if that's the court's decision on that, we understand and appreciate that time. We'll obviously try and focus any discussions.
I understand and realize that it's can be a difficulty. We don't want it to interfere with your communication with your client, but we are going to keep it.
Thank you, Your Honor. Understood. Just on the second issue, then, very briefly, was the deadline to respond to filing F1374. That's the second motion in relation to Rule 154. I don't blame the prosecution for once, which is always a nice thing to say, in the sense that there was a decision issued after they initially filed, which required them, I believe, to provide some more information in relation to the relevant paragraphs of the pretrial brief to which each of the statements of these witnesses applied or related to. So we would, and I'm sure the prosecution are willing to do so anyway, request that they refile the motion with that updated information to allow us to make necessary and focused submissions in response, and also given the number of competing obligations at the beginning of trial and the fact that, as you mentioned earlier, Your Honour, we're not expecting for these witnesses to come for several months, that we be granted an extension of time to respond, so that we would request that they refile or provide supplementary information in relation to the relevance of those paragraphs, and then we would have 21 days rather than the standard 10 days, to respond to that request.
Mr. Halling, any objection to that process?
We would object to having to refile the motion. That wasn't an order to us in your Honor's decision. If that is an order, we just ask to be told by which deadline you would like that. But there's no such deadline to that point. In terms of a response, for instead of it being 10 days being 21, we would consider that to be a reasonable request, and we don't object.
But we would like you to refile, just to be clear, and 21 days will be granted. All right?
Does Your Honor have a deadline by which you would like this done?
Can you give me what you would consider reasonable for you in this case? Because given the fact that, as Mr. Roberts has pointed out, it's not an immediate problem.
I mean, just to be conservative, Friday?
Oh, that's fine.
Thank you.
No problem. Oh, yes, Mr. Ennis.
Your Honor, I apologise. In relation to the courtroom seating issue, I do have two specific concerns. One of them is simply that Mr. Krasniqi is an Albanian speaker. He doesn't converse in English. And so in order to communicate with him, we would request to have an Albanian-speaking team member seated near to him. It's not as simple for us as it is for the others, for me simply to turn my back for a moment and go and speak to him elsewhere in the room. I can't communicate in that way without having assistance. And that does really feed into the overarching point, which is that there are, try as we might to raise things in advance with our client, there are inevitably things that come up in the course of hearings on which instructions are needed. And often needed in the moment rather than waiting for the adjournment. It is going to cause some disruption if counsel and an Albanian speaker to assist are turning their back and moving a couple of rows backwards every time we need to ask a simple point to our client. I hope there isn't a security concern about counsel speaking to their clients.
There's no restriction on that. We will grant leave whenever it's reasonable to do so. You merely need to bring it to our attention that you need to talk to your client.
But, Your Honour, ordinarily, and I'm grateful for the indication, but ordinarily one would simply be able to lean across and
I understand.
do
Ordinarily, that would be the way I would see it too, but it isn't going to work in this particular configuration. You're going to have to go back and talk to him. And I assume you have an Albanian speaker on your team?
Yes, we do.
And
yes.
That person can move there with you when needed.
And can they be situated near to Mr. Krasniqi so that if he has a message he wants to pass to us, he's able to do it?
I will have to take that up with security.
Thank you, Your Honour.
I'm sorry to add an issue that you would have been expecting to have been added by Friday, but one question, it's brief, that arises out of the ruling on Thursday evening, which I had an opportunity to consider over the weekend. evidence submitted to the panel shall be admitted if it is relevant, authentic, has probative value, and its probative value is not outweighed by its prejudicial effect. And paragraph 50 of the judgment notes that the panel is satisfied that this note was relevant and authentic and had probative effect. Plainly, the question remains open whether its prejudicial effect is outweighed by its probative value, an issue that hasn't been ruled upon or indeed we haven't heard from the other defendants about. Now, in your ruling, you say the admission of a record or statement made by an accused does not, without more, infringe upon the fundamental rights of his co-defendants. Again, that proposition, standing as it does, with the without more qualification, begs, it's certainly correct, and we don't dispute it, but it also begs the question, for what purpose? And certainly as a matter of Anglo-American law, and we're doing some comparative research, it's well established that the admission of an out-of-court statement by a co-accused who then does not go into the witness box and adopt it is inadmissible against any other accused. That's the position in Anglo-American jurisprudence. Obviously, we're dealing here with a free appreciation of the evidence rule, but nonetheless, when the court is considering prejudicial effect against probative value, we're dealing here with the statement originally compiled time that the evidence was submitted, it shall be raised immediately after it has become known. Now, that it seems to imply a rule that the defence must raise the issue as early as possible, and if it is raised after the evidence has been submitted, not admitted, submitted, then the clock starts to tick for us to show that we've raised it as soon as reasonably practicable. This isn't an issue about admissibility, ultimately. It's an issue about admissibility against whom and for what purpose, which are different questions. In other words, can it be relied upon for that purpose? So nobody is suggesting that the record cannot include, or I'm not suggesting that the record cannot include that. At the very least, obviously, it's evidence in the case of Mr. Salini. But we will be submitting, and I want to put it on the record as soon as it's become known, so to speak, that that statement cannot conceivably be relied upon as evidence of the truth of its contents concerning the acts and conduct of co-accused if there's no independent testimony from either Mr. Salimi or anybody else verifying its truth. At the very least, it would then be more prejudicial than it is probative, so it would require a reconsideration of 1381, but not to the extent that it has to come out, but to the extent that it cannot be used for that purpose. I'm sorry for raising that late.
No, and on a point as important as that, I would suggest that you file a short written submission to that effect, so that we can rule on it properly.
Yes, I mean, we were, as I said, the timetable for that is the 16th of April. So I'll file that particular issue in advance of that and before the witness testifies, so that you have it.
Thank you very much.
And therefore had to meet the requirement of 1381 of the rules as we treated it, and was treated as such by the panel. My question is, why didn't you raise these issues at the time? Because if there was an objection to admission per se, or as you now say, an issue of admission and or use in relation to the co-accused, shouldn't that have been raised there and then? You will find in a footnote to our decision a number of authorities for the proposition that the statement, in general terms, of a co-accused can, in some circumstances, be used against co-defendants. So my question to you is, why didn't we get the benefit of these submissions at that stage? Because I do have the concern that Mr. Halling has raised right now, that we are in effect in a situation where we will have rolling objections to documents that have now made it to the record.
Well, let me explain very shortly how and why that is. We did, in fact, raise it in brief terms in relation to that document, but our deadline for submitting our arguments in relation to specific admitted exhibits, I'm told, is the 16th of April. 17th of April. So that's the first thing. Secondly, I don't object to its admission into the record. So it's not an objection that would require the court to exclude it. Therefore, it's not bound, it's not too late to make the objection as to how it can legitimately be used. Clearly, it's admissible as against Mr. Salimi, but it's very well established that the out-of-court statement of a co-accused, if not attested to, obviously is of very little weight. Well, when you're balancing prejudice and probative, the rule quite specifically says that the court must make that evaluation. You haven't made that evaluation.
But I'll stop you there. Weight is a separate issue, and of course we will not prevent any of the defense to make submissions on these points, which are perfectly legitimate, to suggest that in the absence of confrontation, these statements, to call them that, should be given little weight. The concerns I have, and I repeat it, is why didn't we get the benefit of these submissions you are now making as regard what you say, or what I understand you to say, the fact that the statements of Mr. Salimi should not be used in relation to your client, which is not the same as giving it weight.
It's not a question of admissibility. That's the short answer. It's admissible. It's a question of the purpose for which it can be used. It's self-evidently not in breach of that requirement to notify in advance, because it's not a challenge to admissibility.
And I don't want to start a full discussion on that, but at the precedent of the ICTY that we've cited, and there's one in the Boszkowski case as well, which was dealt with as an issue of admissibility on that very point. So again, I'm just indicating to you that if you were to seek to make these submissions, that there would be an expectation, at least on my part, that we be explained why these submissions did not come in the first place when the statements, quote unquote, were being offered as associated exhibits. That's all I want to tell you, Mr. Emerson.
Very well. Well, we'll ensure that that is done in the 16th of April submission, which is the current deadline for us to deal with this issue. My concern is that by then it will already be in evidence. So if you don't mind, we'll file an early submission before the witness gives evidence, explaining the basis on which we don't contest admissibility, namely that it can't be used against the co-accused because its prejudicial weight against the co-accused would outweigh any probative value given the circumstances in which it was taken. And that's obviously going to be explored in the cross-examination of the witness as well. So it'd be very difficult to see how one could fully explore that in advance when it's just being tendered and there's no challenge to admissibility. So that, in short, is the answer why the appropriate time to raise it is now.
Thank you.
Sorry. We should have on the record that the amended submission required of the SPO as requested by the Salimi defense should be on file by the 24th of March, and the response is due by April 17th of 2023. One final thing, just in the exercise of extreme caution. I just want to go over the fact that in April, we are meeting the 3rd, 4th, and 5th for opening statements, April 11, 12, and 13, and 17 through 20 for evidence. And in May, the 10th, 11th, 12th, the 16th through the 23rd, and the 22nd through the 24th, just so we all have the dates in mind. Any questions by anybody? Yeah. Just a second, Mr.
Only one, which is...
Mr. Emerson got to his feet first, so...
Sorry.
Go ahead.
Only one, which is that on the published suggested timetable, I think you've just corrected in what you said, but in the published correct timetable, the 10th is shown as a sitting day, when in fact I think it is an official holiday. It is so the 10th of April is the Easter. It's shown as a sitting day, but it's in fact... That's what I assume.
Microphone for the presiding judge, please.
Include the 10th, which is Easter Monday. And I think I explained once again that we have several days. This courtroom takes a lot of maintenance, and so I'd love to be able to have a 4th day some of these weeks, but the maintenance of the courtroom and all of the facilities in it requires it to be vacant for those days. So thank you very much. Anything else by anybody? Mr. Misitich.
I just wanted to confirm that there's no chance that the trial panel wants to hear evidence on the 5th if we go short in terms of the use of time, correct?
Well, no.
Okay, thank you.
That's the short answer. Go ahead, Mr. Keel.
Yes, Your Honor. I raised an issue that it was some part of inter partes concern, and that had to do with this concept of limited use immunity and what that means. I have tried to get some clarity. I know I have been directed by the SPO to Article 38 of the statute. I must say in my career, Your Honor, I've had quite a bit of experience with use immunity, transactional immunity. I have no idea what limited use immunity means, and I tried to delve into the statute and then also the Kosovo statutes, and there is no clarity whatsoever in that regard. Candidly, the outline of any agreement that the SPO has concerning limited use immunity, fails to clarify the ramifications of what is generally known as use immunity. The way it appears here, it is transactional immunity. Transactional immunity use meaning you can't use it against you and we're not going to prosecute you. Transactional immunity means as soon as you come in and you start talking about something, we're not prosecuting you at all. There's no clarification in any of this to say, Mr. X, you have use immunity. I can't use your information against you, but I can do two things. I can develop evidence to prosecute you. Oh, and by the way, if you were a suspect, you're still a suspect. The concept in Anglo-American law and use immunity is that you can't even use the information that person gives you to develop other evidence against you. Now, generally in the jurisprudence of a country or international tribunals, there would be some clarity as to what use immunity is. There is none here. And I have attempted to try to garner some clarity from the SPO, and I've just been directed to Article 38.3, and that's that. And given the fact that we have witnesses coming up somewhat rapidly that have been given what they call limited use immunity, I don't know what the limited means, limited use immunity, I asked the court for some clarity as to what this means, what's the basis for it, and what are the ramifications of limited use immunity as opposed to just use immunity or transactional immunity, and what is this witness protected from and not protected from. Clearly, there's a dramatic difference between use immunity and transactional immunity. Limited use immunity is a concept that is foreign to me individually. It may be clear to others, but it's certainly not clear in the statute and certainly not clear in the Kosovo law. So I raise that because obviously it goes to the credibility of these witnesses who have received limited use immunity, which I suggest they believe thinks they have transactional immunity, which is certainly not the case under the term of art, use immunity. I put a footnote to that because I am uncertain as to what limited use immunity means vis-a-vis use immunity. Suffice it to say, there has been no clarity whatsoever from the SPO in responding to our questions in this regard, and certainly there is no clarity within Article 38 nor the Kosovo law. So I would ask the court if we could have some clarity coming from the SPO as to what the basis in law is for limited use immunity. What is limited use immunity compared to use immunity or transactional immunity? And is it the understanding of these witnesses that are being given limited use immunity that they are not going to be subject to prosecution other than for false statements? Because those are very crucial issues that go to the credibility of witnesses in examining whether or not they believe they are prosecutable.
Anything else?
That's it, Your Honor. Thank you.
Mr. Helling, you want to respond or answer that?
Yes, briefly, Your Honor. Just the mere premise of counsel needing to put a footnote into his oral submission is a good sign that this should be addressed in writing. And that's what we would suggest. These statements of limited use are voluntary, intelligent, knowing waivers. The conditions of them are set out within them, and they are in full conformity with the statutory framework, but we'll respond in writing if that's Your Honor's preference.
Thank you.
If I may just respond, Your Honor has encouraged us, and rightfully so, to have inter-parties discussions on things. So we resolved this, and we're not taking up the court's time. And we did that in several correspondence with counsel. And all we got back was, oh, this is a knowing waiver under Article 38, and that's it. Now, if there is something other, there's something other part of the law here that I'm missing, and it could be, Judge, that I'm missing it. All I was asking for the SPO was to advise us as to what it was and where I should go look for that law, and is there some explanation between limited use immunity, and transactional immunity, and I've received none. Thank you.
Well, I think for your protection and the protection of your client, having the prosecution file a written answer to that question is probably the best.
Yeah, Your Honor, absolutely right. With the threat to forests in the world that this case has brought about, I thought we maybe expedite the matter and get it resolved, but I suppose that's not the case.
We're always hopeful in that regard, but I'm afraid we've failed in quite a few of those instances. Oh yeah. Go ahead.
Your Honor, just a very practical question. The last 2 weeks in May, I'm not sure if I heard it correctly. I looked at the transcript, but I just want to check that our schedule says that we're seated 15th of May till the 18th of May, and then the 22nd to the 23rd and the 24th.
I gotta get to my calendar. We're 15th through the 18th.
15th through the 18th,
Yes.
and then 22nd, 23rd, and 24th.
No, yes, exactly right.
Thank you. I just wanted to check
And,
that.
well, also May 10 through 12. Okay, thank you. When can you have that response?
Your Honors, when the application is filed, I was expecting a written application from the Thaçi defense.
Yes.
We could respond in the statutory timeline or whatever timeline you require.
Well, do we have a witness coming up in which that is an issue?
Yes, not number one in the order, so I think there would be time if the Thaçi defense filed quickly, but we're available on whatever schedule you require.
When are you going to file, Mr. Keel?
It's going to be brief, Your Honor, so
It's
in
okay.
the next few days. I mean, I don't really think it's going to take
Well,
that long.
have it on file by Thursday. This is Monday,
Yes, Your Honor.
and you can respond by Monday.
Understood.
All right. Oh, Mr.
I'm so
Emerson.
sorry, Your Honour, but there seems to still be some uncertainty about the sitting days during May. Did Your Honour indicate we will not be sitting on the 8th and 9th, but will be sitting on the 10th, 11th, 12th? Is that correct?
That is correct.
Very well. And then the next 2 weeks, it's 15 to 18 and 22 to 25. 22 to 20. 24. Very well. Thank you very much indeed.
If there is nothing else, we are adjourned.
All rise.